Good evening, friends. Let us dive into a case law, Janhit Abhiyan versus Union of India 2022, decided on 7th November 2022. This case was put before Honorable Justices, Chief Justice Juju Lalit, Justice Dinesh Maheshwari, Justice Ravindra Bhatt, Justice Bela M. Trivedi, Justice Jamshed B. Parthival. The questions before this constitutional bench were, does the 103rd constitutional amendment providing reservation to economically weaker sections violate the basic structure of the Constitution of India? Second question was, does the exclusion of SEBCs, OBCs, SCs, STs from EWS reservation violate the right to equality? Third issue was whether EWS representations of up to 10% in addition to existing reservations violate the 50% limit on reservations set by earlier decisions of the Supreme Court. So these issues were decided. But let us first go to factual background. On 9th January 2019, Parliament enacted 103rd Constitutional Amendment Act. This amendment inserted Article 15 subclass 6 and Article 16 subclass 6 into the Constitution of India and introduced a maximum of 10% reservation for EWS in admissions to educational institutions and in public employment. This 10% EWS reservation was in addition to existing reservations granted to the scheduled caste, that is already 50%, scheduled tribes, that is already 7.5%, and non-creamy layer of other backward classes, that is 27%. This brought the total reservation to 59.5%. However, beneficiaries of the existing reservation, that is scheduled castes, scheduled tribes, and non-criminal layer of other backward classes were excluded from EWS reservation. A batch of petitions were filed before the Honorable Supreme Court challenging the constitutional validity of 103rd Constitutional Amendment. The arguments made by the petitioners were, firstly, basing reservations solely on economic criteria is impermissible. Secondly, excluding SEBC, OBC, SC, ST from the benefit of EWS is discriminatory. Providing for 10% additional reservation directly breaches the 50% ceiling limit on reservation set by the decision of the Supreme Court. And imposing reservation on educational institutions that do not receive state aid violates the fundamental right to equality. The Union of India contended that economic criteria is a relevant consideration for affirmative actions, and Articles 15 subclass 6 and 16 subclass 6 of the Constitution are in conformity with the equality doctrine. So let us now dive into decision of the Supreme Court. The constitutional bench of 5 judges upheld the 103rd Constitutional Amendment by 3 to 2 majority. Justice Maheshwari, Trivedi, and Pardiwala wrote separate opinion upholding the validity of the amendment. Justice Bhatt wrote a dissenting opinion for himself and Chief Justice Lalit, which found the 103rd Constitutional Amendment to be unconstitutional. All five judges agreed that reservation can be provided based on economic criteria. It was held that affirmative action can be provided in favor of the disadvantaged groups who have been unable to progress due to poverty. The court, by majority of 3 to 2, held that SCs, STs, and OBCs can be excluded from the scope of EWS reservation by treating EWS as a separate class, different from those who are already benefiting from reservations. The majority further found that 10% EWS reservation in excess of the existing 50% limit on a reservation as set out in Indira Sane was constitutional. It was held that the 50% limit is flexible and it may be breached in extraordinary situations. Justice Bhatt, writing for himself and for Chief Justice Lalit, held that the exclusion of SEBCs, SCs, STs, and OBCs from EWS reservations results in discrimination against the poorest section of the society who are socially and educationally backward and have been subjected to caste discrimination. Their exclusion violates the principle of equality. He therefore held that the 103rd Constitutional Amendment was unconstitutional because it violated the basic structure of the Constitution by discriminating against SCBCs, SCBCs, SC, ST, and OBCs of 9 creamy layer. Now, there were reasons for the decision. So let us discuss that also. Reservation can be based solely on economic criteria. The reason is the Honorable Supreme Court unanimously held that reservation based exclusively on economic criteria is permissible and helps in uplifting the poorest segment of the society. It helps in achieving economic justice, which the preamble as well as Article 38 and 46 of the Constitution recognizes. It was held that economic backwardness is not confined only to those who are covered by existing reservations such as SCs, STs, OBCs. Justice Bhatt's dissenting opinion held that reservation based on economic criteria for ensuring access to public goods is permissible. However, the same is not true for reservation in public employment. This is because the aim of reservation in public employment is empowerment through representation of the community. Justice Bhatt held that individuals benefiting from EWS reservations likely belong to socially forward classes or castes which are already adequately represented in public service. The additional reservation for a class that is already well represented violates the principles of equality of opportunity. Exclusion of SEBCs, OBCs, SCs, STs from the benefit of EWS reservation is permissible. The Honorable Supreme Court held that 103rd Constitutional Amendment makes a reasonable qualification between economically weaker sections and other disadvantaged sections already benefiting from reservation under Article 15 subclass 4, 15 subclass 5, and 16 subclass 4 of the Constitution. Since SCBCs, STs, SCs, and OBCs are already benefited from reservation, providing them an additional benefit which is meant specifically for economically weaker sections was deemed unnecessary. It was held that just as equals cannot be treated unequally, unequal also cannot be treated equally. Now, moreover, Honorable Supreme Court emphasized that exclusion is a critical aspect for all reservations to ensure the intended group receives full benefit. It was held that the arguments by the petitioners that excluding these groups is discriminatory overlooks the fact that by excluding the creamy layer, the economically lower strata of SCs, STs, and OBCs are already represented in the categories covered by Article 15.4, 15.5, and 16 subclass 4. Justice Bhatt and Honorable Chief Justice Lalit, in their dissenting opinion, held that exclusion of SCs, STs, OBC from reservation based on economic criteria violates their right to equality. He held that EWS reservation aim to help the poorest members of the society, and poverty affects everyone, regardless of social or educational background. For communities facing social and educational discrimination, poverty has a more severe impact. Justice Bhatt pointed out that it is unclear how excluding those who comprise 82% of the country's population, SC, ST, OBC together, who would otherwise qualify for EWS reservation, would contribute to the upliftment of economically weaker section of the society. He held that the exclusion of SCBC, SC, ST, OBC from the benefit they would otherwise be eligible for because of their social and economical backwardness effectively discriminated against them. Now, coming to the 50% ceiling limit on reservation. The court said the 50% ceiling limit on reservation is not inflexible. Justice Maheshwari held that the 50% ceiling limit on reservations as provided in the case of Indira Sane is flexible. The rule of 50% may be relaxed for compelling reasons and in extraordinary situations. He clarified that no decision of the court could be read to mean that Parliament cannot enact additional reservation if it is deemed necessary. However, Justice Bhatt cautioned against permitting a breach of the 50% rule. He observed that this could potentially diminish the right to equality to mere a right to reservation. Now, friends, EWS reservation in private educational institutions not funded by government is valid. This was held. The reasoning is relying on the decision in Pramati Educational and Cultural Trust Registered versus Union of India, our Honorable Supreme Court affirmed that providing EWS reservation in private educational institutions under Article 15 subclass C does not violate the right to equality. Justice but held that even though reservations in private educational institutions are permissible, this issue is rendered irrelevant since he had concluded the 103rd Constitutional Amendment as unconstitutional. He observed that private educational institutions, despite not being state entities, contribute significantly to national goals by improving educational standards and were not merely entities serving the private objective of their founders. So this is all about, in this case, enjoy the videos. Please share, subscribe, and tell others to listen these videos so that you may be comfortable in clearing the advocate on court examination, which is just coming nearby.